fast. I don't even need it. We can just pray and go home. And we can go. Hallelujah. It is youth Sunday. I see you all who are young, by some age, and those who are young at heart and young in spirit. Hallelujah. And so, people, specially invited guests, to the BCF staff and crew, big up, big up. I can't talk like that, right? It's good Sunday. Yeah, man, yeah, man. And so BCF chairman look sharp. Yeah. Yeah, so what happened now in the Uncle D is that they tell me say is youth Sunday, so I'm dressed like the millennials and the Gen Z. So we can come in a one color suit. You understand? Yeah. And we can't wear no tie, we have to look sleek. So they tell me, so me I try. I try to work with it. Praise God. So we want to just acknowledge and also send our blessings to our brother Tyrese. What's Tyrese first name again? Williams, Ronaldo Williams, who just graduated with his Bachelor of Science in Biology. Back for him, he's blazing the trail for healing and for God. Praise God. Also have online from Mr. David Wilson, Miss Michelle
Okay. Morning, everybody. Good morning. Can you hear me?
Yes, we can.
Excellent. Yes, so sorry about the late start. Thank you so much for being on. And I am Jean Williams Johnson. For those who don't know me, I'm currently the registrar of the Medical Council, having taken over from our illustrious Professor Spencer. So just to let you know that our chairman is Dr. Milton Hardy, and the usual a few bit technical challenges right now. So he'll come on as soon as he can, and he will greet you well. Can I ask Mr. Cameron just to put up his hand for our IT technician, please? Because I think you're using another name on the group. So just to let you know that the meeting is being recorded, and we are so happy that you're here to participate. We're going to have polls later on intermittently, maybe 2 or 3 polls, just to make sure that you're finding it useful. And we hope that you will be happy that you decided to spend your Sunday morning to afternoon with us. So Mr. Cameron, has he put up his hand, Mr. Miguel?
Not yet.
Okay. Yeah, we are sure that he's on, but we're not sure what name he's come on under. So that's why we're asking for him to just put up his hand so we can spotlight him. And once that's done, I'll give you a brief introduction. I'm gonna Okay, good morning again, everybody, and thank you again for being here. Welcome to you all. I gather Mr. Cameron was having a few technical difficulties, but we're happy that he's able to be with us to give us this very important presentation. Welcome, Mr. Cameron. Happy to have you here. So I had explained that our chairman was having challenges, so he's not on as yet. So what I will do, I'll go ahead and introduce you, Mr. Cameron, and then it will be over to you. Okay?
Thank you.
All right. So can I call you Chuck?
Please go ahead.
Mr. Chuck Cameron is the founder of Design Privacy, and this is a consultancy firm that helps companies comply with local and international privacy laws. So you see his relevance. He believes that by protecting informational rights and complying with privacy laws, this allows for the free flow of information and ultimately the generation of wealth. Mr. Cameron is an experienced attorney with 23 years at the bar and has a demonstrated history of working in regulatory compliance in the telecom and financial industry. He is skilled in privacy law, commercial law, and copyright law. He is a strong professional with a master's in information technology and management from the Erasmus University of Rotterdam, with a focus on data protection. And in 2019, he completed an advanced masterclass training as a data protection officer from an ISO certified provider, IT Governance UK in the United Kingdom. Mr. Cameron is also a certified lead implementer for ISO 27001, which is an international standard that focuses on information security management systems based on the ISO IEC 27001. He's also a certified lead implementer for ISO 27701, which is an extension of ISO 27001, and this is for privacy information management that aligns with the Data Protection Act. It is a new standard designed for use by anyone responsible for personal data in any sort of organization. So his company, Design Privacy, currently offers data protection compliance training and consultancy services to companies primarily in the public sector, the financial industry, and the information technology and services industry. Of interest, Mr. Cameron is also a wellness aficionado. He's a yoga practitioner for the past 20 years. And in 2019, he successfully completed his first 70.3 Ironman triathlon in Augusta, Atlanta. Ladies and gentlemen, thank you for being on. And I'm sure you will all agree that Mr. Cameron is more than suitably qualified to talk to us today. And it's indeed my pleasure to invite him to begin. And apologies again for the late start. Over to you, Mr. Cameron. Thank you.
Thank you very much. Let me share my screen. Yes, please do accept my apologies for jumping on late. In addition to the technical difficulties, I forgot I was presenting this morning. But I did something strange. Back in on May 9th, I said I cannot miss this opportunity to really share my insights with the healthcare profession. So from early as May 9, I prepared this presentation specifically for today. So while I may have forgotten on the spot that it was now, I did invest a significant time from May 9, and I don't even usually use a presentation, but I do want something that you could walk away with and be very clear with what this is all about, what you need to achieve, and how you move forward. So thank you very much for the opportunity for sharing. And again, forgive my late delay. Right. Let me hide some of this. But I just need my screen to. Give me 1 second because for some reason I'm not getting it to move. I'm going to stop sharing and start sharing again, please. Right. So let me start sharing again. Yes, I trust you have seen my screen. Good.
Yes, we are.
Yes, please. So this is going to be a packed full presentation. Usually I take the time and drill down into specific aspects, but because I'm going to be leaving you with this comprehensive document, I prefer to do something different on this occasion and just try and cover as much ground as possible. If there is any area that participants want me to drill down into, I will, because I believe I can generate the greatest value for you if you have your specific questions answered. But this is a very packed presentation, and I don't usually try to go through so much in any one sitting, but let's see how impactful we can have it. So we intend to look at the constitutional context first, because that's what makes it important. Then focus on what you need to be doing now. And then after we look at what we need to be doing now in terms of why registration particulars matter, we're going to step back and look at how the Data Protection Act specifically touches on concerns the health profession. And then we look at what a compliance roadmap looks like. And then we'll look at the challenges in Jamaican healthcare. And then, time allowing, we get into some sort of interactive workshop. At the end of the presentation, I want you to be, if there's while I said we're going to be covering a lot of information, if there's any one thing I want you to walk away with, is to understand the constitutional basis for data protection. It's not so important for me that you understand the structure of the Data Protection Act, but that is, we will go through it at a very high level for you to appreciate it. I do want you to understand your specific healthcare obligations and put you on a journey that you can start developing practical strategies. Right, so as I indicated, this is the most important part of my presentation today. How many of us remember when the government of the day was trying to implement or pass the NIDS bill, take it through Parliament, as part of the initiative of implementing this new legislation? They had a very significant PR campaign where the entire population became aware that the government wants to implement NIDS. Interestingly, they got a significant pushback. The majority of Jamaicans, well, a number of Jamaicans pushed back against it, saying that I don't believe in this. This sounds like some 6-6 thing or Mark the Beast or some New World Order thing. And I'm not feeling this. We're not feeling this at all. The more, let's say, rational of society raise some serious questions. They are saying, how do I know that when the government collects all of this information, they will keep it safe? How do I know that they have systems in place to ensure that it's kept safe. How do I know that it's been protected from internal bad actors? And the opposition of the day listened to what the public had to say and actually took all of those sentiments and filed a constitutional motion challenging the passage of the NIDS bill. To their surprise, our Constitutional Court not only declared sections of the bill that they deemed to be unconstitutional, the Chief Justice, our Constitutional Court, struck down the entire bill. On the basis that to collect personal data in this manner without having systems in place to protect Jamaican citizens puts Jamaican citizens at risk. And what at risk means, the Jamaican citizens are exposed to abuse by the government, by third-party private companies. And the court said, until you have developed a robust framework to protect Jamaican citizens, there shall be no NIDS bill, and they struck down the entire bill. In addition to that, and most importantly, our Constitutional Court declared that all Jamaican citizens have a right to informational privacy, meaning that Jamaican citizens now own our personal data and no one can use our personal data without our authorization. And he put it in context and explained that the right to privacy is at the core of human dignity. So I don't need to get into any further details of how the decision was broken down, but that's the starting point. The court recognized the dangers associated with entities using persons' personal data, and declared that this is something that the government of Jamaica and all society would agree needs to be protected, because citizens are at risk, exposed to loss of life, exposed to loss of fundamental rights or freedoms, if it is personal data belonging to data subjects are abused. Interesting, well, so let's move on. So in 2019, we had the decision handed down. In June 2020, the legislation was actually passed, giving us, and it came into effect on December 21. It gave us a 2-year time frame to get our house in order. So while the legislation was passed in 2021, none of the provisions were enacted because it provided for a 2-year transition period. Come December 23, all data controllers were required to register their registration particulars with the Office of Information Commissioner. Failing to register with the Office of the Information Commissioner means that you shall not be processing personal data, and to do so is a criminal offense. So the law says that you shall not process personal data unless you would have registered with the Office of the Information Commissioner. And that provision kicked in as of December 1, 2023. Even before I continue, I still need to give you a little context. If it is a constitution or Charter of Rights says that no one can process our personal data without our authority, or authorization. What does that mean for government agencies and businesses? It means that unless you have someone authorization, there shall be no business. We all know, however, that no right is absolute, save for the right to a free trial. What does that mean? It is not practical that no one can process personal data because business will not continue. However, given the dangers and the possibility of abuse that data subjects are exposed to, the court has recognized that personal data has to be processed. And if you are going to do so and restrict one's right to informational privacy, it has to be done in accordance with the law. It has to be proportionate. It has to be necessary. The Data Protection Act is that piece of legislation that allows third-party entities and medical practitioners such as yours to process personal data. It means, therefore, that it is a Data Protection Act that allows you to do so, and it requires that you follow all the data processing standards set out in the legislation. The Data Protection Act sets out a framework where it actually identifies what are informational privacy rights. It sets out what those data subject rights are. It sets out how you must process personal data to ensure that the risk you're exposing data subjects to are minimized, because the government can't tell you to go ahead and say you can process personal data and not ensure that you put safeguards in place to protect data subjects. Having identified what those data subject rights are, having identified what obligations you have, they have set up a regulatory structure in the person and Office of the Information Commissioner to ensure that you respect the data subject rights and observe the data processing standards that have been prescribed. So why does this matter to healthcare providers? Interestingly, the medical profession are one of the few professions that have been specifically identified in the Data Protection Act. While all data controllers, and a data controller is anyone that processes personal data, makes decisions as to how it is to be processed, while the Data Protection Act covers everyone, it has singled out the medical profession. And that is because you process sensitive personal data. So you'd have seen in the same manner that your profession handles life and death situation, given the sensitivity of the personal data that you process, and how you process it can have significant negative impact on data subjects. And it is for that reason you have been specifically identified in the Data Protection Act. Back in December 2023, the OIC put out a notice where she identified a number of high priority industries and areas, or she referred to it as priority sectors, that you'd expect to be the first in line to register. Because when it comes to enforcement and protecting data subjects, she knows and the law understands and contemplates that this industry processes sensitive personal data. And as such, when we start thinking about enforcement, this is where she'd be looking first. So she did identify the healthcare providers as a high priority sector for registration. What does registration mean? So this is, I want you can take notes here, because this is what ought to have happened come December 1, 2023. If you are now operating a practice and have not registered, you are exposed to criminal sanction. Rest assured, it cannot happen as yet, because the enforcement powers of the Office of the Information Commissioner have not yet been enacted. So Section 16 of the Data Protection Act is what sets out the requirement to to register. What registration means is very simple. If we think about the Office of the Information Commissioner having responsibility for oversight over how personal data is processed by data controllers and ensuring that the regulations and law is being followed, she needs to know what personal data you are processing. So that's the first thing when we speak about registration particulars. That's the first thing. She needs to know what personal data you're processing. She needs to know whose personal data you are processing. She needs to know the lawful basis for processing this personal data. She needs to know, who are you sharing this personal data with? She needs to know, what safeguards have you put in place to protect this personal data that you are processing? And finally, she needs to know, are you transferring this data outside of Jamaica? In essence, she's asking for the very basics. As all industries are transitioning to a more digital world, if it is you are going down this road or have gone down this road, these are all questions that you'd have had to address your mind to. And if it is you intend to go to attempt to digitize your practice, these are the building blocks. And the building blocks are, whose personal data you have, why are you processing it, what personal data you have, who you're sharing with. It's just an inventory of what personal data you have and what you're doing with it and how you're securing it. The Information Commissioner has lowered the barrier to registering. So she has really made it very simple for you to register. So you're not required to provide her all the details that are set out in Section 16, because she's trying to get as many people on board as possible. And she has dumbed down the requirements. If you're interested in getting what those dumbed down requirements are, and even a set template, in attempting to help small businesses comply, we have sought to create a usable template that everyone can use. And because we have served and assisted several doctors and several persons in the medical profession, they would more or less remain the same and consistent. So we have made that available. If you are interested in something like that, put that in the chat, please. Why are the registration particulars important? It puts the Office of the Information Commissioner in a position to discharge her oversight responsibility. She now knows what you have, what you're doing with it, what security controls, and more importantly, what security controls you don't have in place. And it allows her to craft her policy going forward. from your person, with all that data, she knows that she can now assess in general across the sector what are some of the substantial challenges that healthcare institutions are faced with. And by extension, what are the risks that data subjects are exposed to? If it is the medical association were to embrace this responsibility as part of their roadmap to digitalization, as part of accepting the fact that the same way they have a duty to take care of the patient is the same way they have a duty to take care of their personal data, because failing to take care of their personal data would expose them to significant harm, including the loss of life. And you quickly move past the compliance aspect, you would have an opportunity to create your own code of conduct, because the legislation contemplates that industry sectors will identify what is necessary for them in the context of the baseline requirements of the law. How would it practically work in the medical healthcare profession? But if it is you reject it from scratch and you don't do the bare minimum, you'll never be able to reach that position where you can now craft and draft what works in the medical space. You have to start complying with the bare minimum first before you can start charting the way forward. There's a lot of complaint and pushback that nobody was consulted, which is not true. There were extensive consultations, but now the legislation having passed, there's an opportunity to design how data protection should look like in a medical space. So there's an opportunity before, and it's hard-coded in the legislation that industry sectors are being invited to present their own codes that would govern their sector. But before we can do so, you have to comply with the basics. I see there are 4 comments in the chat so far. Okay, just questions. Okay. So the registration particulars represent the heart of your compliance program. So not only does it give transparency to the oversight, to the information commissioner, it gives transparency to your clients. This is a public register where, as it is now, that public register only reflects the name of the data control and the name of the data protection officer. The law requires that your entire registration particulars be made available. There have been a significant number of breaches that have come to the fore of the public. The discerning client who takes his health seriously and the health of his personal data seriously will, once this register becomes available, start using this register to determine whose services they would use. The government will also start, when putting out a request for proposal, require this as part of doing business with you, because they have a higher duty to conform. And if it is you are going to do business with a third party, it is necessary that you can, the person that you are engaging as data processes have also implemented the requisite safeguards. So it offers a great amount of transparency for patients, and it ties back with the constitutional right to informational privacy. The only way I can maintain agency over my personal data, even having shared it with a third party, is when I know what you are doing with it. And that is why the law requires that you state what you are doing with it. So there are a number of real tangible benefits that you can derive. And this is when you're looking at a data protection program in general. As a data controller, as a practitioner, in the same way, you know what medication or what treatment your patient requires. If it is you're in the business of offering health care and you are the business operator, you have to know what information you're collecting and what you're doing with it. So very often there is a complaint that we don't have time to take care of the patient and take care of managing data. Those two positions are inconsistent, and it's the same sort of argument or pushback you'd hear from lawyers or any other professional who have small practices. The reality is, while it is a business, while it is a profession, forgive me, you are offering services to the public, and there are certain basic operating procedures that are required for you to safely offer these services. So one, you get the benefit of a format as to how to document your services. Having identified what personal data you're processing, someone can now be responsible for it. And as we go on, you will see that this information is the foundation of your compliance program. As I indicated, the Information Commissioner on registration doesn't necessarily require a detailed registration particulars. However, the law requires that once a year, every March, you are required to file your data protection impact assessment. And that is where you are required to assess the risks to your clients or patients that you expose them to as a result of processing their data. Let me repeat that again. You are required to identify the risks and dangers you expose your clients to by processing their personal data, and identify what controls have you put in place to minimize those risks. So before you prescribe any medication or course of treatment, you'd have to go back to that detailed, don't even know what you call it, but the detailed information that you'd have collected up front and determine to what extent would this medication negatively impact the patient. And then you'd have to ask yourself, okay, if this is the only solution treatment, how can we minimize those risks? And you have to make a decision. Would the benefits that would be derived from advising this line of treatment significantly outweigh the risks that we're exposing the data subject to or the patient to? That is the exact same thinking that you are to take when determining what personal data you are collecting and how you are choosing to process it. So in completing your registration particulars in a fulsome manner, you are able to identify data flows. You realize that you're sharing information with people that you don't need to be sharing information with. Some information you just leave in a box and is thrown outside to be burnt. You now become accountable and responsible and understand how you use your personal data. So I've been very technical and detailed around what is required for registration and why, why registration is important. I'm going to take a break from the scripted presentation just to give you some insight as to how supervisor authorities across the world have sought to implement and treat with their supervisory responsibilities. So for the past 6 years, every Tuesday morning at 9 o'clock, I would look at decisions that are handed down by supervisory authorities across the world. That I've derived significant benefit from that. And now we have on any given Tuesday morning, at least 40 people, data privacy practitioners, who join us and look at decisions that have been handed down, because that is how we're able to translate what is written in the law and understand from a practical perspective what is important and what is not important, and how what you're exposed to if you don't do A or B. As you'd imagine, there are a lot of decisions that are made or handed down by the supervisory authorities in relation to the medical profession. One of the most consistent issues that are presented to the supervisory authority is who has access to client information. That in and of itself has been the greatest source of penalties that have been handed down. If it is you have a physical file with patient data, or you have automated your systems, it is only the doctor or nurse serving that client, that patient, that ought to have access to those records. If it is you have a hospital and all doctors have access to all client files, all nurses have access to all client files, that has been found to be one of the most common sources of infringement. So back to the presentation, and I'm not going to go much further into risk management, because having created that analogy as to how you prescribe treatments and that process that you would go through, and suggested that's a similar process that you would want to go through for when determining whether or not you're going to use a new system to process personal data or change a process. I think you adequately understand that concept or appreciate that concept. Were there incidents that raised concern about particular help that justified this act? Can you briefly state the rationale? So I don't know if you missed the opening, but I'm going to go back. So why? Because the question of why is very important. So I don't have any challenges or issue going over with that. We have the government of Jamaica. So why we have the act is because the government saw it necessary to allow business to continue. That's why we have an act. Because our constitutional court, in effect, stopped all businesses when it declared that all Jamaican citizens have a right to informational privacy and no one can use our personal data without our authorization. How is this? Why would the Constitutional Court elevate the right to informational privacy to the right to life, the right to freedom of movement? Why is it so important? That that may be the question you're trying to get at, because the direct answer to your question is we have a Data Protection Act because the government saw it necessary to allow businesses to continue, because there's no government agency or entity that has authorization to do everything it does. The risk that citizens across the world have always been exposed to is abuse by government agencies and other entities that have access to their personal data. For example, in Jamaica, a number of young men were killed at Green Bay as a result of the government conducting surveillance, instructing the military intelligence unit to surveil these persons, collect the data, then act upon it. A number of persons were lost in the Montego Bay street scandal when a member of the royal family was coming to visit, and the municipal council used personal data to identify persons living on the streets in Montego Bay, and they were then put in the back of a truck, taken to the Red Mud Lake. And I could go on with several instances where persons have lost their lives as a result of data controllers or abusing personal data, and there be no safeguards around personal data. What does this have to do with the healthcare professional? It has often been said that while Jamaicans have the best doctors that can compete with the best in the world, if someone has an operation or procedure to be done, they would prefer to go overseas to do it. Why? Because before they leave Jamaica, their business will be on the road. And I know several instances, especially that presented itself during COVID, that before someone left a testing center, the public at large knew that that person had COVID. The result of knowing that somebody had COVID, or the thought that someone had COVID, led to the death of that young lady in the beginning of COVID, where no hospital wanted to treat her because of fear. And this is only what is coming out in the public, so I don't know the facts behind it. I could only speak to what came out in the public. A young lady was left to die on a hospital floor because persons thought she had COVID. So if it is you prescribe the wrong medication, if it is you make a mistake with which patient you are looking at, all of these things can result in death. So it's not only if it is, there was recently the biomedical breach. If it is persons found out that I have HIV, even in today's world, I would be ostracized. If it is they found out that I did a paternity test and had a child with someone outside of my marriage, that would mean the destruction of my life. So there are real consequences that are life and death for patients as a result of how the medical profession processes personal data, given the sensitivity of the personal data that you process and what you do with the information that you process. So it's by no mistake that while everybody has the same obligations, the medical profession has been identified because there's a direct association with how you process information and the mental anguish you can cause the Jamaican citizens or whether or not they are life and death situations. So I hope I've been able to clarify that issue for you. I'm very familiar with all that. I'm in support of, but I have never heard a major comment that implicated the medical profession. Well, I hope you understand the context. It's given this quality of the personal data that you process and the impact it can have on the individual if it's not processed in a mindful, intentional manner. So just to, as I said, I'm focusing on registration particulars because that's the first thing you need to do. First thing you need to do. After that, you have at least another 12 months before you have to do the next visible thing. And in terms of a capacity perspective, the Information Commissioner's Office has limited capacity. So the only thing, even when she does have enforcement powers, apart from responding to data subject complaints, her first job would be to ensure that you would have registered. So it is not, you don't need to do any data mapping for registration. Do you need to do data mapping as part of your record of processing and your fulsome program? Yes, but in terms of registering, that's not necessary. You don't need to process and document every process in detail for registration. You don't need systems fully diagrammed for your registration particulars. The reality is the Information Commissioner has dumbed down the requirements set out in the legislation and just wants information at a high level. The Information Commissioner said that registration requires sufficient information to understand the nature of processing without overwhelming detail. And when you look at how it's treated within the UK, they have the similar sort of approach. They emphasize proportionate detail based on organization size and risk. And then there's a case study that I don't think add much more value right now, so I'll skip that over. Right. So the first thing you should have done from December 1, 2023 is register. I've explained why. Very quickly, the overview of the legislation, and I started to touch on that. The legislation in your context defines who a healthcare provider is, and it sets out the scope and application of the Data Protection Act. It establishes the Office of the Information Commissioner. It sets out the primary obligations for registration and the obligations in general of the data controller. It sets out the data processing standards. These data processing standards are standards all data controllers must follow. And when I indicate that the Office of the Medical Profession has been identified, whether or not you're a medical professional or not, all data controllers have the same obligations. All data controllers. When they have been identified, it means that the Information Commission appreciates that by the medical profession processing personal data subjects are at a higher risk. And so when it comes to enforcement, she must take a risk-based approach and ensure there's compliance with those high-risk processing activities first. So the legislation also identifies and establishes what those rights of data subjects are, and finally sets out exemptions. And from a medical health professional perspective, there are exemptions for research, but to benefit from that exemption, it has to be done in a very specific manner. And there are cases that speak to that as well. But when I say exemption, nothing exempts you from having to comply with the data processing standards. When we speak about an exemption, it may mean that you can store data for this specific purpose if you anonymize it. But there is no industry, there's no Ministry of National Security, there's no one entity that has absolute exemption from the Data Protection Act, because we are speaking about a constitutional right. Right, so let's get technical again. And again, I'm going to be sharing this with you so you can refer to this. So personal data means any information that can be used to identify an individual either by itself or in conjunction with any other piece of information. This whole question of the definition of personal data, again, if it is the medical fraternity were to implement the baseline requirements and embrace it, there is a lot of opportunity to, especially because legislation is coming up for review, there is a lot of opportunity to address certain issues. One of the biggest issues that the legislation presents for me is their definition of personal data that includes information relating to deceased persons up until 30 years after. This was a knee-jerk reaction to the same situation that I made reference to earlier, when that young lady died as a result in that hospital, and her mother came down to Jamaica and couldn't access any information. That happened at the same time the last reading of the bill was going through Parliament, and the government of the day grandstanded and included this definition, saying that never again would that situation happen because personal data now extends to persons that are dead and 30 years after. That makes no practical sense. However, that's a very nuanced issue in the healthcare industry. If you were to look at the UK NHS data retention policies, they have gone into very great detail in determining how long, what sort of entity needs to keep what sort of information. And I think that is what the bureaucrats or that's what the technocrats had in mind when they came up with this 30-year data retention period. But that it only speaks to how long you are to keep data, given our definition of personal data today. And this may be a bit advanced, so I'm going to slow down there. I'm getting too technical there. So personal data is any information that can be used to identify an individual either by itself or in conjunction with any other piece of information. When we speak about processing, think of processing as soon as you look at personal data, you are processing personal data. The definition is very, very wide. The legislation prescribes what health records speak of, and it includes clinical information about diagnosis and treatment, biometric information, registration for health services, genetic data, testing information. How the impact of the Data Protection Act on not even the Data Protection Act, the constitutional right to informational privacy, and the fact that I now own my personal data has changed fundamentally how you view your records. Up until 2021, December 2021, or 2023, sorry. No, 2021 when the law was passed. Our common law said that if it is you were to assess a patient and write your notes, you own the intellectual property in those notes, and you don't have to share those notes with anyone, including the patient, because that represents your intellectual property. That, however, is modified if it is necessary to be shared with another medical institution for the purposes of getting health treatment. The medical profession to date has taken that to ridiculous lengths. And again, that is why the pushback by Parliament and making it saying that even dead people have a right to their personal data. An experience I had was where a mother and father came to me because they wanted to find out what happened to their child that they just gave birth to, and the hospital was not giving them any information. We wrote to the hospital to get this information. They ignored us, not even a response. We filed a court action without the information to ground it. But before the matter started, we asked for a preliminary order instructing the hospital to give us this information. The court granted the order. We took the order and served it on the hospital. The hospital ignored the court order, indicating that you are supposed to provide the medical records around this child. I then went back to the court, indicated that the hospital received it, but ignored it. I then had to start contempt proceedings to lock up the keeper of the records for ignoring the court order. We all know that is standard practice in Jamaica, and that is an extension of that intellectual property that you now own. The Data Protection Act has changed all of that. The patient now owns his information, and if the patient says, "Can I have my records?" it's a criminal offense if you don't hand over his records to him. So that is one, it's necessary for you to, piece of information you need to leave here with, because today, up to recently, went to a physiotherapist. Physiotherapist did a very detailed, robust examination and did captured all the information. I asked her for a copy of it, and she said, "No, I don't usually give it out." And I just reminded her that there's a Data Protection Act. I didn't go into anything. And I told her that it was a very, very serious request. And she reluctantly handed it over to me. Right. So health records, data controller, and so who is a data controller is a big question in the medical profession, because very often doctors are associated with hospitals. They have their own, they work together. They share spaces with other doctors. They work by themselves. So there is a very big question as to who is a data controller from the medical perspective. So we have to appreciate the definition of the definition of a data controller. A data controller is any individual or entity that makes a determination as to what information you need and what you do with it once you receive it. So if it is you work in a hospital or let's work with the private clinic scenario first, where you have an entity that manages the administrative work of the clinic, but doctors come in and offer services. In those circumstances, you are a data controller, not the private clinic, because you determine what information you need from the patient. You know what questions you ask. The private clinic, on the other hand, is acting on your behalf in the circumstances where I go to a private clinic to see a specific doctor. If I don't go there to see a specific doctor, the private clinic becomes a joint data controller, because the doctor is still a data controller, because when he's interviewing that patient, he's the one that determines what personal data is collected. The administrative arm of the clinic only needs to keep only receives the information that the doctor would have collected. And the private clinic has no interest in the information, save for the fact that they are collecting it and managing it for the doctor. So in that circumstance, the private clinic, where a client goes to see a specific doctor, that specific doctor is a data controller. The private clinic would be that data processor. A hospital, on the other hand, where a patient is not going to see a specific doctor, but is going to the hospital that's closest to them, the hospital would be the data controller. In those circumstances where it is a consulting doctor, and I'm not even sure if I'm using the term consulting doctor correctly, forgive me, but when I use the term consulting doctor, the doctor is not employed to the hospital, but he has a contract with the hospital. And again, I'm not suggesting that is correct. I'm just going off of my layman's understanding of what those relationships look like. That doctor in that situation would be a data processor, because the patient is putting his trust in the hospital, not necessarily the doctor. And the hospital supposed to have experts available that know what to do and what information they need on behalf of the hospital. I hope I've identified a real pain point, and I hope I've been able to address that pain point, give some clarity around that. If it is you engage any data processor, the law requires that you have an agreement in writing. So if it is you send the client to someone, to a third party, a biomedical labs, or a biomedical labs, for example, biomedical labs would be a data processor. You would be the data controller. So even in a biomedical lab situation, you are ultimately responsible, because you sent the patient to that lab or a lab to get a test done for your purposes. The lab didn't say, okay, we need to run this test, this test, this test, this test, this test, this test. The doctor prescribed what test needs to be done and recommended what lab they should go to. So in data processors are not subject or do not fall under the purview of the Data Protection Act. It's the data controller that is responsible. the whole question of, given the difference in that relationships the medical profession has with doctors and clinics, doctors and hospitals, and how they use labs, there is a lot of work that should be done by the medical profession to clarify those relationships and make it consistent with where the responsibility should really lie and how it should work. Again, to reach there, you have to bring yourself under the operation of the act. As I indicated, a lot of persons complained that there was no consultation with the individual entities or sectors before the legislation. That is not so. However, the legislation contemplates and invites professional bodies such as yours to produce your own codes to determine how the legislation would work in your context. And I'm suggesting to you, this is another area that you can look at, defining the relationships between doctor and doctor and doctor and clinic and doctor and hospital and doctor and labs and ambulance service providers. Dana Boss says, though there's a standard among the medical fraternity that notes are made, is there a mandate in the law that compels physicians to make notes? Well, that's a medical practice question. That would be a copy of the records, not the records for doing it, so it would have nothing to stand on further investigation. Can I pay part of the notes? If it is incorrect, they are in a position to, they have a right to demand that it be corrected. But if it is you are making a medical diagnosis or prescription, they can't determine what is right or wrong. But can a patient request part of the notes be changed? Yes, if it is incorrect. If you have spelled their name incorrectly, if you have captured their wrong address or whatever, it's objectively incorrect, that is within their knowledge, they have a right to insist that it be corrected. And on the other hand, one of those data processing standards is that you maintain accurate records. That's not something new. That's not something burdensome. That is something that's part of your obligations. But you are now being held to account by the Information Commissioner if you do not indeed maintain accurate records. So an interesting question is asked. In Bahamas, we use an electronic record system which appears to be linked to multiple labs and can be transferred to other doctors. If a patient chooses to switch doctors, a patient switches, does the new doctor become liable if the initial doctor has incorrect information? What is required is that any doctor receiving personal information has a mechanism, a reasonable mechanism in place to guarantee the accuracy of the information. So what that means is, as soon as you get it, you can give it to the data subject and say, is this accurate, or whatever mechanism that's necessary. Can the new doctor release the old records? Also, once you appreciate and accept the fact that I own my data, you'd appreciate the answer to that question. If it is information about me and you are now in possession of it, you are the data controller, you have to give it to me if I ask for it. So we have looked at, so when I say that the medical profession processes sensitive personal data, it's referred to as, well, I've broken down exactly what that is here. Importantly, while the legislation has specifically identified the medical profession, the law has also created special lawful bases that doctors can also rely upon, understanding that it is unique. So one of the first data processing standard, as I indicated, that you're required to disclose to the Office of Information Commissioner in your registration particulars. But outside of that, one of the first data processing standard, and a data processing standard are standards that you must follow if you are going to process personal data. The law has given the medical profession not only that additional responsibility, but also additional bases upon which to process personal data. So you can say one of the reasons that I'm collecting and using this data is it's necessary for medical purposes. When you're processing special category data, not only do you have to follow the first set of data processing standards, and those data processing standards are in general, there must be a lawful basis, you must notify the data subject, you must only collect the information that is necessary, you should only keep the information as long as is necessary, all the information that you collect should be accurate, you need to have security controls in place, and before you share it with a third-party country, you need to satisfy yourself that the third-party country has a robust mechanism in place. The first data processing standard is when I say it must be lawful and fair. There are several elements of what lawful processing is. It can be lawful if you have consent. It can be lawful if it is for the medical profession, necessary for medical purposes. It can be lawful if it is in furtherance of a contract. But this is where it gets technical and you need some sort of help to do this. Another requirement that the Data Protection Act speaks to that I did not put at the top of the presentation is the requirement to appoint a data protection officer. So those are the three hard obligations that you have. That one, you must register with the Office of the Information Commissioner. Because you process sensitive personal data, you must appoint a data protection officer. That has been a challenge for the medical profession. The law says that you can outsource data protection officer services to a third party. Appointing a data protection officer is not a nominal exercise, or you just can't nominate one to say that you have one. Your data protection officer has specific statutory responsibilities. So when you're thinking about getting a remote data protection officer, you want to satisfy yourself that they have robust processes in place and frameworks in place that they can show you that would put them in a position to comply with their statutory responsibilities. Those statutory responsibilities include informing you that there's a data breach within at least 24 hours. Those statutory duties include informing the Information Commissioner that there's a data breach if you, the doctor or the data controller, fail to notify the Office of the Information Commissioner. There is a misconception in the public because a lot of persons have been trained under the GDPR and this whole IAPP certification that the data protection officer is the whistleblower in the organization. That is incorrect and not consistent with the Jamaican Data Protection Act. It is the data controller who has the responsibility to notify the Office of the Information Commissioner of any breach. It is only in circumstances where the data controller has failed to discharge their statutory responsibility that the DPO has a role to play. So, one, ensure that that data protection officer has robust frameworks and processes to ensure that they can fulfill their statutory responsibility. Because if it is you do not report a data breach within 72 hours, that is a criminal offense. And you are relying on that data protection officer to notify you that there's a breach so that you can then notify the Office of the Information Commissioner. Another statutory responsibility of the data protection officer is to ensure that they manage the data subject access requests. So when a data subject says, can I have all of my information, or can you let me know what information you have on me, or can you rectify this, or can you send my information to X person? That data protection officer that you use must have a robust framework that he can demonstrate to, that he can discharge that responsibility. When you choose a data protection officer, you must ensure that that data protection officer has a robust system to manage your third parties. Remember, when I was saying that you need to clarify what is the relationship between the different stakeholders, that data protection officer is responsible for identifying who those third parties are and managing that relationship in terms of data processing agreements. I am aware that there is an entity or individuals who just provide us some documents and say, we are your data protection officers. If it is, they have not demonstrated that they understand what their statutory responsibilities are, and that they have robust frameworks and processes in place to discharge their responsibilities, to serve one doctor, much less several doctors. At all material times, you are left accountable. A data protection officer does not bear any accountability or liability under the Data Protection Act. All accountability and reliability is on the shoulder of the data controller. And this is limited to the medical profession. This is for all data controllers. It will be the best case scenario if it is that entities are offering data protection, remote data processing. Let me repeat that. It's a best case scenario that if it is a data protection officer is offering remote services, that not only does he have robust processes, not only does he have robust frameworks, but it would, in the ideal situation, those processes and frameworks would also be supported by software. Because the question is, if it is you are serving several persons, even with the robust processes and frameworks, how do you discharge your responsibility to more than one entity at a time? So there have been several cases, as I indicated, that have been treated with both by the European Court of Justice and the supervisory authorities across the world. At this stage, because the Office of the Information Commissioner enforcement powers has not yet been invoked, there are no local cases. These cases are relevant because these are the exact same resources the Information Commissioner would rely upon when advising or informing herself as to how to treat with issues that have been placed before her for resolution. This European case, here, by way of example, identifies IP addresses as personal data. So while we are detained and focus on patient records, remember the definition of personal data is any information that can be used either by itself or in conjunction with any other person or any other data to identify an individual. Let me see here. What are they? When you get your medical records from the physiotherapist and the data leaked because of your mishandling that data, what are the implications for the physiotherapist faces in this situation? I'm not sure if I fully understand the question, but if it is, they're making reference to the information, the scenario that I painted on my personal circumstances. If I leak my personal data, that is on me. There is no, I'm not a data controller, I'm a data subject. So a data controller is the only implication is whether or not the data controller provided me with the information. But if I cause the information to go public, that is my right. I own my data. I am responsible for my data. Will data have to be requested verbally in writing? All data subject requests must be in writing. A distinction needs between changing the medical record, the notes versus person. The law is very clear. The law is extremely clear. The comment, I mean, a distinction needs to be made between changing the medical record, the notes versus personal info. The law, and this applies across all sectors. Notes taken about an individual form part of personal data, and that's not special to the medical profession. That's part of the definition of personal data. So if you're in any profession and you make a personal note about an individual, that qualifies as personal data. And so when I suggest that the profession needs to get together and address certain situations, unless you can make a case, a strong case that justifies that, that is a non-starter. And when we say make a strong case, we can make reference to the decision that was handed down on Friday in relation to whether or not states of emergencies are constitutional, the states of emergency were constitutional. What the government failed to do is provide empirical data that those states of emergency were necessary. When we speak, and that the whole question of states of emergencies touches and concerns the right to due process and the right to freedom of movement and the right to freedom. In the same manner, the right to informational privacy is a charter right. It is a constitutional right. If it is, you are going to ask legislation to change any part of the law that is going to further or could further expose the data subject. You have to have, you must demonstrate that it's necessary, proportionate to the legitimate objective you are trying to achieve, and there's empirical data to support it. What if you give the patient their medical data and then he or she gives it to someone else? That has nothing to do with the data controller. What if the data subject is lying about their name and address? What the law requires is that you have some form of system to ensure the information you collect is accurate, whatever process that is. A very simple solution is, let me see your ID. If that's a fake ID, that is okay. You would have put a reasonable mechanism in place to guarantee that the information is correct. If the public healthcare system in the Cayman Islands, whenever patients request their own records, they are directed to medical records department. That makes a written document of this format. So that covers the medical health. If in the public healthcare system, the Cayman Island, whenever patient records request their own records, they are directed a medical record department that makes up written request for this record for medical. So that I don't understand the conclusion. You first have to determine who is the data controller and who is the data processor. And once you determine who that data controller is, you will be in a position to say that, okay, the medical record is acting on behalf of the data controller, or the medical records department is the data controller. But that statement is, there's a lot of nuance beside it. There's no black and white like that. Good day. What should be done in the event that printed or written notes are given to the patient is lost or misplaced by the patient? That is, we've had several questions like that. And I don't know if I'm sufficiently expressing myself or communicating, but that has nothing to do with you. It is his data. He's responsible for it once it's in his possession. No, a doctor cannot hold on to records until a fee is paid. Neither can a lawyer, neither can any professional. It is my information. Should I ask all my patients how many years I should keep their medical records? No, I indicated that this is something that the medical profession needs to sit down and come together and work out. And you can take guidance from the NHS. The patient doesn't, you are the one who knows, well, when we speak about data retention, it is informed by the law. It is informed by your business objectives and your business processes, and it's informed by third-party requirements on that personal data. The data subject doesn't determine what your data retention policy is. I would like access to the revised document, please. Just to be clear, is the case that any doctor that works at a private that does not directly employ them needs to register? This question, just to be clear, is it the case that any doctor that works at a private office that does not directly employ them needs to register with the OIC? If it is, you see patients and you collect personal data, the answer to that question is yes. That then speaks to the question as to how you organize your business and revisit your business. If that is not practical, for the fourth time, I'm suggesting that the law contemplates that professions look at their specific scenarios, look at what the legal requirements are, and make recommendations that as to how the law should operate in the context of how your business or your profession works. But as it is today, a data controller is anyone who determines what information that is to be collected and collects it on his own behalf. So if you have an office in a private entity and you are collecting personal data, yes, you are a data controller. In a similar manner that a lawyer that has a single practice has to register with the Office of the Information Commissioner, so do you. Can one use? No, the data, the information, well, it's not written in black and white, but the Information Commissioner has said that data protection officer ought properly be based in Jamaica. The rationale behind that is that there must be someone to hold accountable and subject to local laws. I would like to have access to the revised document. Also, what if the notes have sensitive in regarding patient sex and it is formed by? I'm not sure about that question. All right, so I'm going to go back to the presentation. Right, so this comes up at a timely. This slide is relevant in the context of the question that was just asked in relation to the GDPR. There are while the Jamaican Act mirrors the GDPR to a very great extent, there are some fundamental differences. Unfortunately, persons who are trained under the IAPP certification, be it CIPP or CIPM, they are purveyors of some of these inaccuracies and falsehoods. The first inaccuracy that I brought to your attention was whose responsibility it is to report to the Office of the Information Commissioner a breach. Under the GDPR, it is the responsibility of the data protection officer to go straight to the Office of the Information Commissioner and report a breach. That is not so in Jamaica. It is the responsibility of the data controller to report the breach. Once the data protection officer becomes aware of the breach, he is to inform you in writing of the breach, and then you are left with the responsibility of going to the Office of the Information Commissioner. If it is you fail to do so, he has a duty to follow up. As it relates to registration particulars, the GDPR has a similar record of processing. However, in Europe, you are not required to file your record of processing. In Jamaica, you are required to file your record of processing as part of your registration exercise. In Jamaica, you are required to conduct a data protection impact assessment every year. In Europe, you are not required to do so. You are required to ensure that you can demonstrate to the Office of the Information Commissioner that you conducted a DPIA before you engage in a processing activity, but you don't have to proactively file it. When there's a breach, or if the Information Commissioner was just conducting an investigation, she would ask, can I see your data protection impact assessment? Can I see if you addressed your mind to the risks you are exposing data subjects to? And can I see what controls you said were necessary so I can now assess whether or not you put those controls in place? Because once you can demonstrate you have considered the risk and done your best effort to manage those risks to the data subject, that is what you're required to do, because there will always be breaches. There will always be breaches. You are just required to ensure that you considered the dangers that you expose a data subject to by processing this data before you do so, and identify what controls are necessary to manage those risks, and ensure that there's a plan in place that you follow to get the job done. So similarities, similarities, we define in personal data the same way. To process sensitive personal data, they are required to have enhanced protections. They are the similar core processing principles and similar data subject rights. Registration is more explicit in Jamaica, as I stated. You have to file the annual DPIA. There are different enforcement mechanisms and territorial scope variations. And then it is often said that I'm already compliant with HIPAA. What else do I have to do? So both of them, the Data Protection Act and HIPAA, focus on health information. Security safeguards, both of them require security safeguards. Both of them have patient rights provisions, and both of them have breach notification provisions. So those are some common foundational principles for protecting patient privacy. There are some substantial differences, however. Jamaica covers all personal data collected, not just health information. The consent models are significantly different. Registration is not required under HIPAA. And under the Data Protection Act, there are broader individual rights under the Jamaican Act. So being compliant with HIPAA does not equate with being compliant under the Data Protection Act. In general, there is a much more comprehensive scope under the Data Protection Act. There is a higher documentation burden, and the patients have additional or expanded rights. Well, coming out of your own office, healthcare providers with HIPAA compliance programs will need to expand their practices to meet Jamaica's more comprehensive requirements. This session is meant to be for 3 hours. Do we usually take a break with this sort of 3-hour session? I'm prepared to proceed, but do we usually take a break? Because it is a lot of information, and I'm not getting any feedback right now from the administrators. So I am going to recommend that we take a quick, let's say 10-minute break. We come back at 5 minutes past 1 and continue.
Yes, Mr. Cameron, we'll agree to that. Thank you very much for that consideration.
Yes, please. All the
All
best.
right, okay.
So as we proceed, let me answer some of the questions in the chat. Also, how should I deal? Also, what if notes have sensitive information? How should I deal with this scenario? If patient died and relatives request for change of personal details like name or date of birth or address. So this is because of the definition of personal data. If it is, they provide you the requisite legal documents such as a probate or letters of administration. That has to be, you have to follow those instructions once they can demonstrate that it's incorrect. But this is one of the areas that I'm suggesting that the medical association or your profession in general has to address this whole question of what is personal data, especially when the law now says that personal data is data belonging to persons that have been dead for 30 years. Dead people don't enjoy constitutional rights, and the Data Protection Act gives effect to a constitutional right. So on every level, it was mistaken, as I indicated, it was a political grandstanding when that was amended while the bill was passed through the upper house. In the case of laboratories, is what you're saying that is currently stands, because the doctor is a data controller, even though a data breach may have occurred, the level of the lab information, the person is a data controller. That is 100% correct. The person that is responsible is the doctor. He's a data controller. The data protection, the data and the laboratory would be the data processor. So in the instance of the medical labs, the biolabs breach, doctors who would have sent their patients to biomedical labs to get some lab work done is the data controller. This scenario or situation in relation to the relationships that doctors have with different third parties, I think is a unique situation, and the law invites professional bodies to submit codes to determine how the legislation would work in your space, because the law or parliament contemplated that no one law would fit everything. But unless you respond to my call and organize yourselves and start to comply and embrace the legislation, you are going to be left subject to this situation where if you're a single practitioner and biomedical labs breach happened, you are the one that is responsible. Is there any law guideline at present as to how long do medical professionals have to keep records on a patient? No, there is none. This is work that I'm recommending that your association needs to do, and you can take guidance from the NHS medical retention policy. It is very robust, but it has to be tailored for our local scenario. There's a difference between how long a doctor has to keep up medical records as to how long an individual doctor has to keep a medical record as to whether or not the hospital just saw the person one time, whether or not you are the last person to see. There are a lot of nuances, and it is work that needs to be done, and that is something that is well suited for your association. If I'm an individual doctor who is a data controller working for a private office, am I required to hire a data protector? If you are all data controllers are required to appoint a data protection officer across the board, whether or not you pool the administrative expenses through the private office and appoint a DPO that would represent all of you is a different situation. But as a matter of straight law, you have the individual responsibility as a data controller to appoint a data protection officer. does it make sense for the private office for you to pool your resources and appoint and have the private office appoint the data protection officer? Yes. What are the penalties for data breaches in the Act? It ranges from imprisonment to 4% of the gross percent of your profit to $2 million and $10 million. There are a variety of sanctions that are tools in the Information Commissioner's toolkit. Thank you for your kind words. Thanks. If a doctor shares patient data with a specialist consultation, who assumes the role of data controller or processor? That is somewhat of a hard question. I would suggest that they are a joint data controller, because remember what the definition of a data controller is. Anyone that makes a determination as to what information is to be processed and how it is to be processed. You cannot tell a consultant, and again, this is from my layman's position, you cannot tell a specialist consultant what information he needs. You will give him the information you have, and then she will then determine what other information she requires. And because she has the autonomy to determine what information she requires, and she has her own Hippocratic oath and guided by independent set of same regulations, I would come down on the side of them being a joint data controller. Patients oftentimes choose which lab they attend. So would that hold true if patient choose a form? And I'm reading the question that patients often determine which lab they choose. Patients oftentimes can choose which lab they attend. And because of those nuances, I'm going to suggest that this is an area that your association needs to generate some codes and guidelines for submission to the Office of the Information Commissioner. Because without more, that lab is working on your instructions. So if it is, you tell the patient, you need to get this done. And when you get it done, come back to me with the information. That is okay. You have no relationship with the lab. You made a prognosis and said, you need further information, patient, go and get that further information. That lab will not be your data processor. If that lab, however, if you are the entity that says, go to this lab, get this work done, and have the lab send the information back to me, he's conducting that examination on your behalf. These relationships are highly nuanced, and I cannot do justice to answering these relationships questions with such fleeting information. As I've suggested, these are areas that need to be fully explored. And after that full exploration, submissions made to the Office of the Information Commissioner, or guidelines shared throughout the organization, because the relationship between who is a data controller, who is a data processor, and who is a data subject impacts significantly on what your responsibilities are. So let me get back to the presentation. No, the assumption is that the data protection officer is not a doctor, because if it is that the data protection officer is a doctor, that means there would be a conflict of interest in that he may be asked to oversee his own processing of personal data. So let me share my screen again. Right. So I have attempted to identify the 5 high-level things that a compliance program looks like. No, well, this is not what a compliance program looks like. Let me take that back. I've attempted to distill the 5 core activities that you must do, because very often people ask for a simple checklist. Let me start by saying there is no simple checklist. However, I have sought to simplify what compliance could look like for a single practitioner. So the first thing you need to do, and I spent a lot of time on this, is register with the Office of the Information Commissioner. And you do this, you renew your registration every year, and you have an obligation to maintain and keep those registration particulars updated. The next thing you have to do is assess the personal data that you are processing. In the same way you make a determination as to what treatment you could implement or prescribe, and you assess the patient's history and where they may have been a negative impact, and you do that whole assessment that I spoke about. That's the equivalent of a data protection impact assessment. So you need to assess what personal data you're processing, how you're processing it, how would this restrict the rights and the fundamental rights and freedoms of the data subject, how would you expose them to risk, how would you mitigate those risks, and is it worth it? Is it necessary and proportionate? So the same way you say, do the benefits outweigh the downside? It's the exact same sort of consideration you're required to make. Because you there are a number of data processing standards when we look at step 3. You are required to comply with all 8 data protection standards. But what the bare minimum, and there's no, I need to be very clear, there is no going around or no shortcut. But at a bare minimum, ensure that you have updated patient notices and you have implemented a robust consent management mechanism. Then ensure that you have implemented technical safeguards. You cannot do that by yourself. You do need a service provider, as in a Microsoft, or a technical service provider. Then you need to establish organizational measures. A DPO, it is not the responsibility of the DPO to implement organizational measures, but very often that DPO is trained in what needs to happen. And they may play a dual role as a consultant and a data protection officer. What you must have in place is a mechanism and procedure to respond to data breach notifications. To respond to data breaches and respond to data subject requests. So at a high level, these are the must-haves. These are the absolute must-haves. Does this equate to the implementation of the Data Protection Compliance Framework as mandated under the Jamaican Data Protection Act? No, it does not. But dependent on the size, if it is a one-man shop, these are some of the things that you must focus on and get done, and it will serve you well. Because this is a risk-based exercise. Section 30 of the law requires you to operate within your pocket. It requires you to operate within, take into consideration the available state of art. It requires you to consider the amount of risk you're exposing data subjects to. It requires you to consider the amount of personal data you're processing. So it's not one size fits all. So what I have here is the very basics you must have in place for a single practice. And let me say it again. Does this put you in full compliance with the law? No, it does not. We have gone through registration, and if it is the members, last week, Thursday, we put on a registration workshop. Don't know how many of you are aware of it. If it is a certain number of members express an interest in having such a registration workshop, we will gladly put on a workshop, a webinar workshop for you, where at the end of the workshop, you would be in a position to register. So this is, as I've indicated, the Office of the Information Commissioner has significantly simplified it. And because we have done it, we have done it over a significant period of time, we can walk you through the registration process in under 2 hours with some preparatory work that needs to be done, especially in light of the fact that all of you process the same personal data. All of you share personal data with the same third parties, and all of you need the same sort of protection in place. So that is something that we are prepared to do if a number of persons indicate in the chat that they are interested. So that's the health specific information we're prepared to walk you through. And then we go through, as I said, we will take you through registration for those who have not registered as yet. Step 2, this is a more challenging, detailed part that you cannot do by yourself. And why is it challenging? And this is challenging for privacy practitioners as well, because you are required to understand what risk management is in general. You are required to understand what fundamental charter rights are. You are required to understand how to conduct a necessity and proportionality test. And all the things I'm speaking to here is exactly what the law says you must consider. And if you are to look at Section 45 of the Data Protection Act, you would see these same things. These are the different components of your DPIA. You would be required to be able to identify what are controls that can minimize restrictions of charter rights, what are controls that can minimize information security breaches. So it requires a wide domain of expertise. And there are very few, even outside of you in your practice, there are very few privacy practitioners that are in a position to do that. What we have done, so we have been able to simplify that. And as I was indicating earlier, when you are outsourcing these services, for them to serve several persons, they must have a robust framework. So any service provider must provide for you in writing, what is their data protection impact assessment methodology? Show me how I am to do this. Because if you are making one spend and investing one time, a DPIA is something you have to get done, not the data protection officer. So any privacy practitioner you are engaging, they have to teach you and leave with you a methodology to get this done. So not only have we developed a methodology for the medical profession, we have created a software that has simplified the entire process. And when I say simplified, once you use our system to compile your registration particulars, we take all the work out of it and everything is done automatically. Additional DPIA triggers. So I have given you that analogy again with how you prescribe treatments to what a DPIA is. Right. So step 3, inform and consent. So one of the underlying principles of the Data Protection Act in general is transparency. Again, it is only when data subjects know how their data is being processed are they in a position to exercise their rights and protect themselves. The first data processing standards is that you must process data lawfully and fairly. Section 22.6 describes what fair processing means, and it means that you must issue a privacy notice. They don't make reference to the word privacy notice. Privacy notice is a term adopted from GDPR. So the more technical term, or accurate term, is a Section 22.6 notice, where you let them know what data you're collecting, who we are and your contact details, what information you collect and why, the legal basis for processing, who you share it with, the data security and retention periods, their rights and how to exercise them, and separate explicit consent checkboxes if necessary. Consent is one of those lawful bases. As I indicated, under the first data processing standard, it must be lawful and fair. There are at least 8 lawful bases that are available to you to rely upon, and one of them is consent. And because you are processing sensitive personal data, more than likely you'd often find yourself using this in addition to another lawful basis. And under the Jamaican Data Protection Act, it is not straightforward. Fortunately, the Office of the Information Commissioner has provided a form that you can use. I don't know if that has improved or increased efficiency, but if you follow that or make your best effort to follow that, you will be in good stead. Four, technical safeguards. As I said, you do need a third-party provider to do this unless you are technically inclined. The law mandates or makes reference to encryption, access controls. Well, the law doesn't speak to access controls. The Jamaican government has identified ISO 27001 as its official information security standard for the country, the National Information Security Standard. So that outlines what are the bare minimum requirements. I have, however, identified some of the bare minimum things you must have in place. Encryption, access control. So encryption means if it is somebody hacks into your system, they can't see what information is there. Or if it is your laptop gets stolen, that is a data breach. They can't see the information. If it is your jump drive that has personal data on it gets lost, the information is encrypted. You are not exposing data subjects to any danger. Encryption is your get out of jail free card when there's a breach, because the data subject will not be exposed to any harm. Access controls. This speaks to the same issue that I raised near the top of the presentation when I gave the example of the case where it is a breach of the Data Protection Act if doctors were to have access to other doctors' patients. audit login, critical, secure communication, device security, then organizational measures. So this is where you leverage a consultant or their data protection officer can offer these type of consultancy services to ensure that these things are in place. Risk-based approach. So as I indicated, it is a risk-based approach. Not all sizes do not fit everybody. One size does not fit all. Finally, these are the basic processes you must have in place. You must have a breach notification process in place, which entails documentation of all breaches, risk assessment process, OIC, when appropriate, communication with affected investigates. As I said, it is, the question is data subject. Did you have a process in place to ensure that they would have been notified as quickly as possible? Did you have a process in place or training in place for persons to report the breach as soon as it came to their attention? These are all things you must be able to prove to the Information Commissioner to avoid sanction. You're not going to be sanctioned. Well, dependent of the nature of the breach, you may not be sanctioned if you can prove that you sought to put all the things prescribed by the law to minimize the chance of it happening. And here we set out the breach procedure. Then you must have a process in place to respond to data subject requests, which could be either they want to access their data, they want to correct something, they want to delete something, they want to object to something. You must have a documented process in place upon which persons are trained to be able to enable data subject rights. Let me quickly take some questions. Your head is projecting over the slide. Can this be corrected? Yes. Let me share again. Sorry about that. I was looking at some questions. What if the hospital uses a third-party cloud storage to store patient data? Who is a processor? That third party, be it Microsoft, be it any specialized cloud service, is the data processor, and the data controller is responsible. The law requires that you must have data processing agreements in place for all your data processors. And this is this is one of the responsibilities of the data protection officer to ensure is in place. Okay, no more persons are interested in the workshop. Are there any provisions for a medical practitioner to apply for exemption? No, that I have not clearly, I thought I spoke to that very clearly. No, I'm not going to go into that any further. Interested in CME? Can this be recorded available? I would be interested in getting a copy of medical records. Retention. I trust this is the NHS. Injured register sites. Injured, okay. Right. So compliance framework. So I indicated you want to ensure that you would have registered, you have at a bare minimum You know how to conduct your data protection impact assessment. You can demonstrate that you would have published privacy notices. You would have done your security control assessment, and you would have tested your process to respond to a breach. And this is the responsibility matrix may well be overkill because you may not have all of those resources. And that is why I just focused on the 5 most basic things that you should have, regardless of your size. So the implementation, usually it took 2 years to implement a program from beginning to end. And that is why the law provided a 2-year grace period. However, with robust processes, with having done it a number of times and having automated a lot of the activities, the entire process can be completed within the initial data elicitation and the initial registration and assessments can be completed within 6 months. Right. So, what have been some of the challenges? So, 78% of Jamaican medical practices are still primarily paper-based. That can make, regardless of whether or not you have a paper-based practice or digital practice, both paper and digital practices or digital records fall under the purview of the Data Protection Act. It doesn't make a difference. When you have both a digital and physical, it doubles the amount of work that you have to do because you have to ensure that the controls are implemented for both paper-based and your digital records. When we speak about looking at the challenges of a private practice, if everything is paper-based, to what extent are customer patient files segregated in that filing drawer? Doesn't the private entity usually view it as the clinic's patients and the secretary has access to everybody's file? Or does each doctor have access to their own filing cabinet for which they keep the key for? Record management and retention is that big issue, is a very big issue across all industries. The good thing for the medical profession, the NHS has done significant amount of work for this. We now need to come together as a working group or working committee and determine what is appropriate in the Jamaican circumstance. I saw that someone did post some document in the group. What document is that, please? Is it may well be, let's stop. Let me see what document that is. Right. So yes, retention is a big piece. And the more you keep records, the more your costs increase. And you're responsible for them. And the greater you unnecessarily expose data subjects. Because if you don't have their data, if you destroy their data, there can be no possibility of any breach. That's the thinking behind it. If you don't have all of these archives, there's no reason to be renting space or taking up valuable storage space, valuable office space as a storage room. So there is a direct cost benefit to implement a robust data retention process and there is very clear protection from liability with a robust data retention process. So phase 1 and phase 2 and phase 3 and phase 4 isn't recommending any new thing. These are things that if you are operating a business, a professional business, these are things that you would already have in place. Right. These are general. I would focus on the continuous training cycle. You must ensure that all persons in the organization are trained on data protection fundamentals. Understand from a practical perspective, this should be done yearly. Because one cannot ignore the challenges that you are faced with in terms of resources. If it is, however, you appreciate why this is important, and if it is, you do your research and make informed decisions as to how to get it done, there are robust, affordable solutions today. 6 years ago, 5 years ago, 3 years ago, 1 year ago, the number of persons in the market to offer this type of services was extremely limited. As such, costs were extremely high because a service provider had to make a decision. Do I work for one big company that can pay my bills and my staff, or do I work for several small practitioners who I cannot serve and cannot pay my staff? Today, you have several providers in the marketplace. Today, you have, well, you don't have, well, as a result of being in the market for so long, we have now been able to, as I indicated, automated all of the majority of your compliance requirements. So whereas you'd have been quoted astronomical figures 1 year ago, 6 months ago, because processes have been able to be automated, those costs have significantly reduced. Are there costs associated with maintaining and implementing your data protection compliance program? The answer is yes. What I'm inviting you to do, in light of the fact that this is an informational right to privacy we're speaking about, hoping that you would have an appreciation of the danger you're exposing data subjects to as a result of processing their personal data, you do take your fiduciary duty to your patients, not only physical health, but their emotional health, and it extends to their physical health as well, seriously. And there is an additional cost. The question is, to what extent do you come together as groups? But especially when you're looking at a software solution, they have been so priced that your average small practitioner should be able to afford it. So the whole question of costs and resources that were very reasonable arguments 2 years ago no longer exist. the whole question of the service provider you rely on in terms of information that is available to you to make an informed decision is no longer an excuse either. Right. So I'm going to focus on the questions for the next 5 minutes. Only that interesting. All right. So I don't think that there are any more questions. I'm going to quickly try and put a link in the chat that would, so for all those persons who are interested in getting this presentation and sign up for the webinar for registration, I will quickly do so. But that ends my presentation. It is hoped that you leave here with these basic information. One, you have an appreciation of why data protection is important. And you appreciate now that we're speaking about a constitutional right that we have all agreed must be protected, and why failure to treat with personal data can lead to extreme consequences for the data subject, as extreme as death, loss of identity, incorrect treatment, emotional distress when their information is leaked. Two, you are very clear on what are the things you must do. Those things that you must do include register with the Office of the Information Commissioner, appoint a data protection officer, conduct your DPIAs. Those are things that you must do. I shared a 5-step program that captures, that does not make you compliant. I can't emphasize that enough. But these are the 5 things that if you do, you will be ahead of the pack and should put you in good stead over the next 5 years until you can do everything that you ought to do. And finally, that there are no options in place that you can take advantage of. And with that, while I try and put this link together that I did not do beforehand, I'm open to taking any questions through orally because I can't look at the chat right now. But thank you very much for the opportunity. And as I indicated, I'm just trying to quickly submit this, put this link together. Please tell me if this works. So, everyone, I'm putting a link in the chat now. Please confirm if it works because I did this very hastily. Just click on it and see and quickly fill it out and let me just see if it works. If it doesn't work, I will be sure to get it back to the organizer so they could share it with you, the date for the presentation and the sign up and the presentation itself, because they have your email addresses. And so I will share it with them if it doesn't work now. Back over to you, Madam Host, Mrs. Williamson Johnson. Okay, so I will have the link circulated with the organizers of the webinar by
Yes.
tomorrow, where you can
Yeah.
all sign up for the registration and get the access to the presentation, please. So
Okay.
I'll ask administration to share it with you all.
Okay, thank you very much, Mr. Cameron. I'm going to invite Dr. Milton Hardy, who is the chairman of the council, to acknowledge appropriately. Dr. Hardy, over to you.
Yes, thank you very much, Madam Registrar. First of all, let me apologize for not having been on for the beginning of the presentation. In fact, I got the entire presentation, but due to technical problems, I was unable to unmute. I did, however, send my welcome via the chat, so I hope you read it. First of all, let me thank our presenter, Mr. Cameron, for his very comprehensive presentation to us. I'm sure we learned a lot, and we will leave here today with a wealth of knowledge about data protection. We also need to thank our hard-working organizing committee, chaired by Mr. Colin Virgo and other board members of the Medical Council. And for Medical Council members who are not members of the PR committee, I also thank them for their support. I must thank Mr. David Miguel, our IT consultant, who has been with us from the planning stage to registration and support for our CME offerings. Must also thank the registrar for getting the program going and to greet the participants in my stead. And of course, we must thank the participants who, without you, there would be no program. Thank you very much for coming. Enjoy the rest of your Sunday. And thanks again for taking time out to share with us this experience, which, as you notice, carries no cost and is done as a courtesy of the Medical Council of Jamaica. Thank you. Thank you, Madam Registrar.
Yes, thank you very much, Chairman. And good afternoon to you and everybody on this meeting webinar. Thank you. Thank you, everybody, for being here. Bye.
Bye-bye.
Yes, thank you. Okay, take care now. Bye.
All righty.